Good afternoon. Thank you all for joining us and welcome. This is the first of our series, the Wildcat Community Think Shop. My name is Valentina Morales. I am joined today by our executive director here, Edward Arsenault, my friend and colleague, William Eric Waters, and we have a wonderful group of panelists here. They are experts in the field. I will introduce them shortly, but I'll turn it over to our executive director, Ed Arsenault, just for a couple of words before we begin.
Good afternoon, everybody. Thanks so much for making time to be with us today. We're so excited about this opportunity to collaborate with these great thought leaders. Valentina will introduce them in a moment. And those of you at the FedCap group know how proud I am to be a colleague of Valentina and Eric's. Christine McMahon, the president and CEO of the FedCap group, asked to be remembered to everybody. She's excited about the work of Wildcat. We also have two of our board members participating today. Mark O'Donoghue is the chair of the board of the FedCap group, and Nancy Settergren, who has been on the FedCap Rehabilitation Services Board for a number of years, and most recently is now on the Wildcat Service Corporation Board. So welcome to Mark and Nancy. We're grateful to have you with us. I expect we'll have a robust and engaging conversation. And with that, I'm going to turn it back over to Valentina and these great thought leaders. Thanks, everyone.
Great, thank you so much. So before we begin, here at Wildcat, we are a community of workers and thinkers. Our work is valuable and it's varied. It spans the spectrum and it includes for some of us personal growth and healing, all the way through and including other work, which is characterized by long-term paid employment. As an agency and a community, I think we appreciate the great power that lies not only in work, but also in opportunity. And as a community comprised of individuals who have been impacted by and or directly involved in the criminal legal system, we appreciate the barriers to opportunity and to economic well-being that derive from that very system and impact not only individuals, but families, communities, and future generations. And so with this in mind, we have pulled together this, what we call a community think shop. And this is the first of a series of roundtable discussions where thought leaders come to our space to introduce, address, and explore with us options for changing the impact landscape of our criminal legal system. And so today we're going to be discussing what we're calling the perpetual punishment of criminal records. And this is a conversation about the impact of accessible automatic expungement and all that that entails. And so joining me today are some really incredible thinkers and doers. In the interest of time, I'm just going to share maybe a sentence or two about each of them, but you can find their full bios on our website and some more about their work. We are extremely fortunate today to be joined by Margaret Love, who's an expert in this field. Margaret practices law in Washington, D.C. She specializes and has for many years in executive clemency, restoration of rights, sentencing and corrections policy. Margaret's also the executive director of the Collateral Consequences Resource Center, which maintains the Restoration of Rights Project. And I'm sure we'll hear more about that during the discussion today. Welcome, Margaret, and thank you for being here. Next, we have Avery Bazell, who is the community organizer for the Community Service Society of New York's legal department. And Avery is organizing the Clean Slate New York campaign. Avery also oversees CSS's New York Reentry Roundtable, which is a quarterly forum that brings together reentry advocates from across the state to formulate strategies to assist with reintegration. Lisa Perlman joins us from the Office of the Brooklyn District Attorney. Lisa is currently the chief of the sealing unit and answers motions by individuals seeking to seal records of nonviolent convictions. She also handles post-conviction motions for resentencing, which are made under the New York State Domestic Violence Survivors Justice Act. and Lisa previously served in the Conviction Review Unit at the Brooklyn District Attorney's Office. Welcome, Lisa, and thank you for being here. And last, we have Anna Roberts, who's a professor at St. John's University School of Law. Anna was previously a public defender. She is a scholar of criminal procedure and evidence. Her recent work continues to examine the meaning attributed to arrests and to convictions, among many other topics. I'm very excited for Anna to be with us today. Each of the speakers today that will be discussing this with Eric and I approach the topic from different vantage points. And I would say that no two share exactly the same opinion on what we'll discuss today. In terms of the format, we will have time for questions at the very end. If you have questions, please do put them in the Q&A feature. My colleague Eric is going to facilitate the question and answer portion of the discussion. He will be looking out for your questions, so please send them along. So let's get started. And just to set the stage so that we're all clear about what we are talking about, I thought that we would begin with Margaret on some vocabulary. And really, Margaret, maybe you can take us through this. What is the difference between a criminal record and a record of conviction? Or when we talk about a criminal record, what are we talking about? What does that include?
Sure. The universe of criminal records is considerably larger than simply conviction records. There are a whole variety of non-conviction records, ranging from arrests that were never even charged, through charged cases that are dismissed, acquitted, diverted, all situations in which a person ends up with no conviction record and they are legally innocent. But these records remain on the rap sheet in many cases, most cases, in fact, permanently. There are only a handful of jurisdictions in which non-conviction records are sealed automatically, only a handful. And for the rest of them, in many, many states, individuals have to go and actually ask the court, make a petition, sometimes after a waiting period of all things, to seal or expunge a criminal record. So that is sort of the second half of what I'm going to say now is what is the difference between sealing and expungement if you're talking about what you do about a conviction record. Well, that's a really interesting question because in many jurisdictions, there's very little difference at all. And the terms are frequently used interchangeably. When we at the CCRC did a model law on non-conviction records 18 months ago, we chose the word expungement intentionally because we thought it was a far more substantive sounding word than sealing, which was simply limiting public access. On the other hand, we did not provide for destruction of anything. In fact, I am really opposed to, my first career was in history and I am kind of opposed to destroying anything. And in fact, in many jurisdictions, even if the law says that the record is deleted or expunged, in fact, there is always a copy of the record somewhere in the court record system. So it may be destroyed in the local law enforcement offices. It may be destroyed as far as background screeners are concerned. It may even be destroyed as far as law enforcement is concerned, but there is a record somewhere. Sealing, there are a variety of effects in many cases. The record is still open to anybody who is required by law to do a background check. And there are a lot of entities, employers in particular, who are required by law to do a background check. So the point here is, and I won't belabor this at great length, the point is that these terms are very slippery. They don't necessarily mean anything in particular as a functional matter. And you really have to look at each state's law to determine what the effect of this record relief is.
All right, thank you. Thank you so much. That's helpful because actually when I was reading and kind of speaking with people, there seemed to be some confusion about, well, what are we talking about? Are we talking about a criminal record, which includes records of, non-conviction? Are we talking about conviction? And so we'll focus most of our discussion today on conviction records. And when we're talking about conviction records, just to set the stage for everyone who's joining us and thinking about kind of the impact, just how many people are we talking about? And in terms of the data that is kept, there does not seem to be a definitive number of how many people are living in the United States with a conviction record. Based on the information kept by federal agencies, it seems that there are an estimated 100 million individuals that have a criminal record, and there are about 19 million people living with a felony conviction. I couldn't myself, and I don't know if any of the panelists have a number, but I couldn't find a number for the number of people living with misdemeanor convictions in total across different states. But I was able to find that in New York State, there are about 2.3 million people living with a conviction record. And just to kind of take us into my next question, which I'm hoping Avery can talk a little bit more about. A record of conviction is a permanent public record, and it triggers a host of legal and social consequences. So consequences that are defined in laws, administrative regulations, et cetera, and social consequences like discrimination in employment or discrimination in healthcare or housing, et cetera. So Avery, I'm wondering if you can just talk to us a little bit about the impact of criminal convictions, maybe some statistical information as it relates to employment or health outcomes or housing or voting.
Yeah, so thanks for having me. And yeah, while a felony conviction carries perhaps the greatest stigma, even a minor record can be a life sentence to poverty in this digital era. 9 in 10 employers, 4 in 5 landlords, and 3 in 5 colleges that are using background checks to screen applicants' criminal records, right? And as the use of that has grown, so has the number of laws and restrictions that limit access to jobs, occupational licensing, credit, housing, education, and other basics. So people with records potentially face some 50,000 such restrictions. So a criminal record reduces a job seeker's chance of getting a callback or job offer by nearly 50%. Formerly incarcerated people are nearly 10 times more likely than the general public to experience homelessness. And if not for mass incarceration and the barriers that's associated with having a record, the nation's poverty rate shown in a study would have dropped by 20% between 1980 and 2004.
Wow.
If we talk about the country, nearly half of children in the United States now have at least one parent with a criminal record that has negative consequences on that child, right? On their life chances, hampering their either cognitive development, school performance, educational attainment, employment, and earnings in adulthood. And in New York, when we talk about voting, if you have a felony, you can't serve on a jury, but you can vote, right? But also there's a lot of misinformation out there, and I think it's by design, that people think that they actually can't vote, but they can, right? And we need their voices to go to the polls as well, and have that. But I also think when we talk about these statistics, like we have to talk about the stories as well, right? Because the personal is political for me. When I think about the people that are involved inside of the Clean Slate campaign, I think about folks that are involved, that are leaders in this campaign, one being a VP of policy, right? At a prominent organization that is facing barriers to getting housing and the effects that that has on her kids, right? And when we're talking about generational stuff. Another person, a leader, has been out for years, has done great strides, was trying to get life insurance so that they can just bury themselves, right? And that got denied. And thinking about other friends that have, are EDs of organizations, doing great work, and, was trying to travel. So his family, it was his daughter's birthday, so he was going to bring them with him to LA. And was going to get an Airbnb, and that was, once he gave in his ID, they ran the check and they permanently barred him from Airbnb, right? So those are some of the impacts that we talk about that come into play when we talk about having a conviction history and why we have to be doing something about it.
Thank you. Thank you for sharing that. Yeah, I mean, when we couple that with the sheer magnitude of people that we're talking about, I think that brings us to the importance of this conversation here and to thinking about exactly what that means for communities and what that means for generations to come in those communities. So I'd like to maybe now turn to the meat of our conversation and spend some time here. Since we're talking about records of conviction, and Margaret spoke a little bit about this at the outset when defining some of the terms for us. There are and there exist in different states forms of relief with respect to whether we're talking about sealing or expungement and using those terms interchangeably. And for the most part, they are discretionary, although now there are some that are automatic. And so I'm just going to again refer to Margaret's expertise here. And maybe just if you could tell us what's the difference between discretionary and automatic relief. I mean, it seems to spell it out in the word, but it's a bit more complicated perhaps. And maybe you could just take us through the characteristics of each as they exist now.
Well, actually, there's a third category in there too. Yeah, it's if relief is automatic, it happens without having to ask for it. This is a growing movement, particularly influenced by a very recent and amazing article that was published in the Harvard Law Review by two University of Michigan law professors that found that even though many people were eligible to expunge a felony conviction in Michigan, only 6.5% of the people who were eligible ever got the relief because it was simply too hard to go through all of the very complex procedures. So there's been a trend toward making relief automatic, and there are a handful of states, Pennsylvania, South Dakota, surprisingly enough, New Jersey, Utah, and a few states that are making relief automatic prospectively, but they don't affect records going backwards. California is in that category. North Carolina just passed a law. There is another category, which is that relief is mandatory. New York's non-conviction sealing has always been in that category. Yes, you have to ask, but you can ask right at the moment that the record is disposed of, when the charges are dismissed, when you're acquitted, when your diversion is successfully completed. You ask the court right then and there to seal, and it's a mandatory sealing. There is one exception, but I understand, actually Judy Whiting told me that it's never used as something in the interest of justice or some vague formulation like that when no one ever uses it. That's a mandatory sealing, and that's been around literally for decades. And nobody is supposed to get those records, non-conviction records, except upon court order. Now there's been litigation over whether the NYPD has been improperly accessing those records. I'm not sure what the status of that is right now, but theoretically, you're not supposed to be able to get those records. The discretionary area is by far the most common where convictions are concerned, and particularly felony convictions. In fact, New Jersey and Michigan now are the only two states that authorize automatic sealing of felony convictions. California going prospectively. But both Michigan and New Jersey, when their systems come online, that's important because they're not online yet. They will apply to many felonies, not all felonies, but many. The technological challenges of automating a system of relief are considerable, particularly if additional eligibility criteria are factored in. I don't want to get too far down the agenda here. Maybe I should just stop there to say that yeah, discretionary relief is a pain in the neck, and there are a lot of access barriers. that are making people increasingly feeling that we need to make lower the barriers at a minimum and make relief automatic if possible.
Thank you. And now I'd love to turn to New York State, because you mentioned New York State, Margaret, and the automatic sealing of non-conviction records that's been, mandatory automatic sealing of non-conviction records. And I'd like to turn to this issue of conviction records in New York. And Lisa, if you could just talk to us about the current sealing statute. So there's a current sealing statute which does cover some felony convictions, and maybe if you can just talk to us about the statute and what has changed since the statute came into being in terms of law, and maybe some of the challenges that remain. But if you could maybe just take us through the sealing statute, that would be great.
Sure. So thanks for having me today. I'm glad to be part of this conversation. Back in October of 2017, New York State passed the sealing statute, and that statute allows, by moving in the court, a motion on the part of the defendant to seal nonviolent criminal convictions. And so by that, there are limitations and eligibility requirements. And just to run through the eligibility requirements, you can't have more than 2 convictions over your lifetime. You cannot have more than 1 felony conviction, and you cannot be applying to seal more than, it's either 2 misdemeanor convictions that you can apply to seal, a misdemeanor conviction and a felony conviction, or one or the other. At least 10 years have to have passed since the conviction and sentence. And then that, of course, excludes any time that was spent in prison or on probation or parole. So it would be at the completion of that 10-year clock would start going. And then there are, of course, crimes that are ineligible offenses. Anything that requires one to register as a sex offender, all sex offenses, all homicide offenses, and all violent felony offenses as defined under by the New York State penal law, as well as Class A felonies. And I'm not sure if I'm leaving anything out, but that gives you the idea that the more serious crimes are not eligible for sealing. And of course, you can't have an open criminal matter pending at the time that you make your application. So this is a great start because it finally does allow people that do fall into these eligibility requirements to have these cases sealed. And prior to this, I believe that the only means of any relief was to obtain from the court a certificate of relief of disabilities, which, it's vague. What, if anything, that really, it sort of seems to send a message that the court absolved you a bit, but I'm not sure if it's practical application in terms of licensing applications or reapplications and things of that nature. But having the case sealed is certainly a much better outcome for somebody who is trying to move on from collateral consequences that other members of this conversation have sort of outlined. So this has been an improvement. You also asked about what challenges remain.
Yeah, I mean, I know that you do some work in the community, kind of just even getting the word out. So I'm wondering if you could take us through, what challenges remain.
Sure. So what happened was, with all due deference to the powers that be, when this law was passed, I was tasked by the district attorney to set up a unit to field these motions. And when I took a look at the application that was drafted and implemented for the public, I found it to be not user-friendly at all, very, very tedious, very, very confusing. And I got a group together, a counterpart of mine in the Bronx DA's office, an attorney at the Legal Aid Society, and 2 attorneys at the Legal Action Center. And we sat around a table and said, we've got to make this better. And we actually, I got the Office of Court Administration to say, okay, we will be receptive to changes and edits that you suggest. And I believe we made the application better. The application is, by anybody's estimation, still very long, but it's meticulous. And if you can just stick with it, it's a much more user-friendly application. That process was very long to work with OCA and to get it actually implemented, to have a new version up on the website for the public. And so it didn't make logical sense to me to start going out into the community with a very cumbersome and confusing application. And so we were waiting for that to be revised. And once it was revised, I started going out into the community to certainly say, hey, this is an opportunity that exists, and to sort of explain it and to get the word out. So everybody can look at, the calendar and understand that, by November of 2019, when I started going out, it wasn't too long after that I couldn't go out anymore, when the pandemic sort of hit a few months later. And so that's been on hold, unfortunately. But, there are other ways in terms of challenges. I think that when this came out, I would have expected to see this up on billboards on every highway, commercials on TV, sponsored by the state. I mean, that would be, my suggestion. I certainly, won't speak for the district attorney himself, but I have been handling this and other post-conviction issues and criminal justice reform. In that vein, I think that the message needs to get out, because I think a large part of this is just, why would people know that they have this opportunity? One suggestion that I also, hope to see happen, that's being spoken about now, is when people do obtain a conviction, whether they take a plea or they're convicted of, however they're convicted in court, I think that it would be beneficial to advise them that, and I understand that, maybe within this conversation, there might be some difference on what this time period should be, but for now it's a 10-year time period. But they should be advised, in 10 years, you can come back and move this court, if it's an eligible offense, so that somebody at least is on notice that this is not necessarily permanent, and plants the seed to, hey, don't give up all hope, for some of the, psychological reasons, where a conviction might saddle someone and say, well, I've got one conviction, my record's marred forever, and I may as well just, go down a different path. In terms of how many people are left out, and I guess a little later in the conversation, we can talk about, my view on the automatic expungement might differ, but I do believe that many are left out of this sealing statute. And I wish that there was more discretion for a variety of crimes to be considered for sealing, because sadly, I see, very, very compelling applicants put in, a motion for sealing, and their particular crime is not eligible, and there's no discretion. And the areas specifically are violent felony offenses. I think that, many of these cases are very serious, and maybe they shouldn't be sealed, but we should at least be able to get them before the judge, particularly in New York State. And I certainly by no means mean to make light of gun possession. It's a very, very serious offense. But I've seen a large number of applicants who have one contact with the criminal justice system, and that was for possession of a loaded firearm. And you know what, in the 1990s, in certain neighborhoods, that maybe wasn't crazy behavior and did not define a person, it defined a time period. And so when 20 plus years has gone by and they are living a very, very productive life, and that felony conviction can't come off their record, it's a frustration. And I think that some of these applicants should be able to go before a court and have a judge weigh in on that. There are also other violent felony offenses, particularly having to do with individuals that were young at the time and would, perhaps at that time have qualified and been eligible for youthful offender status, and that would have turned into an adjudication as opposed to a conviction. And maybe that was denied at the time and they're saddled with a conviction now, but now we know so much more in terms of the raise the age legislation. We know so much more about people under the age of 25 and impulsive nature, and perhaps we would look at it with a more mitigating eye. So I believe that those cases should be able to get in front of a judge. There's so many cases where I don't think that the DA's office would oppose these. Many we would, but the vast majority of cases we want to see people move forward. The last area that I would say, because the sealing statute limits people to 2 convictions over one's lifetime, sometimes there are several convictions, but you just look at somebody's rap sheet and you say, oh, they had a substance abuse problem, just by the timing and the types of the convictions, whether they're larcenies or drug possession or sale, and they're kind of clumped together over a 3 or 4 or 5 year period, and maybe there's more than 2 convictions, but it's really a substance abuse, and we could almost look at that as one larger conviction, and that should be able to come before a court for discretion, because people are being punished from moving on from a time in their life and they can't get past that. So I'd like to see the sealing statute as it exists now, amended and broadened to include these areas. And I guess I'll turn the conversation back to the group.
Thank you. Thank you so much. I appreciate that. So with that, I'm going to ask Avery, why clean slate? So there's this existing statute in New York for sealing. What's clean slate going to change? And why? What are the potential benefits?
Yep. So Clean Slate New York is a statewide campaign and coalition to push and call for the New York State Legislature to pass automatic record expungement in the state of New York. What we are proposing is a 2-step process and a 2-step system to end the perpetual punishment of a conviction record. So first, automatically sealing convictions for most civil purposes, like employment and housing. And then second, after a longer period of time with no subsequent convictions, automatically expunging those convictions. So in the civil sealing, a conviction would be sealed 1 year after sentencing of an individual's last misdemeanor conviction and 3 years after sentencing on their last felony conviction, not including time incarcerated, if that individual is off probation and parole, if the individual has no pending New York criminal charges, and that individual is not on the sex offender registry for that conviction. When a conviction is civilly sealed, it will be inaccessible for most civil purposes, including use and background checks for most employment and housing, and will be inaccessible to police departments. People will not need to disclose a sealed conviction for most civil purposes. And sealed convictions will, however, remain accessible to the criminal legal system, including the court, prosecution, and agencies that are statutorily mandated to fingerprint for civil purposes. And then we move towards full expungement, right? Which is a conviction will be fully expunged 5 years after sentencing on that individual's last misdemeanor and 7 years after sentencing on their last felony conviction. If that individual is off probation parole, has no pending New York criminal charges, and is not on the sex offender registry for that conviction. And once the record is expunged, it will be inaccessible, and individuals will not need to disclose it for almost all civil and criminal purposes, with the exceptions of gun licensing, applications to be a police or a peace officer, federal jobs, or jobs with federal clearances, which specifically include full record searches and not subject to the New York State law, immigration related purposes, or for criminal system purposes that are explicitly mandated by law, for example, enhanced sentencing. Why? Because there's 2.3 million people that Valentina, you talked about earlier, that have a conviction history, right? Because the sealing statute 16059 is not meeting the need. It was a great first step, as Lisa said, but one that has many problems because of its limitations. And while they said there was going to be 600,000 individuals who would be eligible for it, it's been less than 2,500 people that have gotten that across our state. That's 0.05%, right? And that's a problem, right? We had it's a 10-year waiting period, which is very long. So somebody comes home and then they have to wait 10 years. We had a client at CSS that they put in and it took 1.5 years, right? So on top of that, 10 years, they had to wait another 1.5 years to actually get that motion to get their record sealed, right? That's why, because Black and brown communities have been over policed. They've been excessively prosecuted back in the 90s, like Lisa was talking about. And because prior to the pandemic, there were 700 clients that came to CSS's doors each year, right? Trying to be full participants inside of their society. And each month, more than half of the room came to us thinking that they could get their record expunged, and that didn't exist in New York State. And we got tired, you know, Fannie Lou Hamer says you're tired of being sick and tired of being sick and tired. We got sick and tired of being sick and tired of lowering expectations for folks, right? So need to be doing something about that, because other states are doing it, have done it. There's been no problems. And New York constantly says they're a progressive state, but our criminal justice system is not progressive at all. We're behind the 8 ball when it comes to this stuff. So we have to be not just catching up, but we need to be ahead, right? Because other states like Michigan and Pennsylvania and Utah and South Dakota, as Margaret said, have passed it, right? And because we focused a lot on a lot of different things in the New York State legislature, like police reform. We've done stuff around bail, but we have to be doing something when people come out. Once a person is out of the criminal legal system, that system should no longer have to be involved. We have to be asking the question is, at what point are we saying it's okay to return to society so folks can have jobs, right? So that folks can be full participants in their society. This is not about the criminal system. This is about moving forward. And it's about people that are out the system, right? You've done wrong, you've done harm, you go into the system, but then you come out, and we tell people to get a job. We tell people to get housing, and actually there's a whole bunch of barriers that stop people from doing that. Because we're in a pandemic, right? And in this pandemic, it has led to another recession, right? And people who had conviction histories were discriminated against prior to that, and they will be discriminated against while we're all talking about the economy. They'll be the last ones to be hired. So we have to be passing clean slate legislation now in this economy, in this state, to make sure that everybody can get a chance and can get ahead. And what's the benefits? There's a research study from the University of Michigan that finds that a year after a record is cleared, people are 11% more likely to be employed and are earning 22% higher wages. And we know that's a good thing, right? So those are just some of the reasons why we need to be passing clean slate.
Valentina, I want to just interject a quick question. Someone put in the chat, and I would like Avery to speak to this. And does the Clean Slate Act provisions provide for automatic certificates of rehabilitation? And is it even relevant if your conviction is sealed? Would you even need a certificate of good conduct or rehabilitation?
Yeah, I mean, once your record is sealed, like we wouldn't really need to be talking about this anymore, right? Because people will be able to get their housing, get the things that they need around employment and stuff like that. If it was to pass the way it is, and you know, like we still have to be talking about that, but for what purpose, right? Because people are getting the relief that they actually need to be able to be participating in our society. And like Lisa said, it's not really meeting the need as much, right? It's not doing all that we would want it to do. So it helps in some cases, and you know, folks come to our offices to apply for it, and we help them out. But this would be pushing that further, and you know, making people really get what they need.
Thank you.
Thank you. Thanks so much, Avery. I'm going to turn to Lisa just for a couple of minutes to hear counter arguments to the automatic expungement that Avery has discussed in terms of clean slate.
Sure. So I want to just start by saying that I absolutely agree that there are many that deserve to just move completely on from the collateral consequences of a criminal conviction. But I guess where I differ is that I don't believe that it's everyone, and that there are concerns that so where I'm stuck is with the automatic piece of it, and that this isn't there isn't discretion, that this isn't coming before a court or a prosecutor to weigh in on. And rather than just talk about that generally, I'll just offer a few quick examples that I think, that I've come across, even under the current sealing statute, where we might have, somebody that's otherwise eligible. So forget about people that wouldn't even fall into the eligibility requirements as it exists right now. I had a case where it was a misdemeanor assault, and the applicant was saying, it was many years ago, and I really would like to get a job at a daycare facility. I'm also looking into adopting a child. And when I looked into the case, it turned out this misdemeanor assault actually stemmed from a felony assault, where this applicant was indicted for severely beating her niece and son, and with her husband at the time. And he pled guilty to the felony assault, and she pled guilty to the misdemeanor assault. But this is certainly not the kind of thing that we would not want a potential employer of a daycare to know about, or an agency that's screening for adoption. I had another case where, what about drunk driving convictions, where somebody wants to be a school bus driver, somebody wants to be an Uber driver, somebody wants to be a truck driver, just get back on the road. And, everybody can drive a car, but somebody that's really going into that as their profession. And, not only for the public safety, but for the employer liability of hiring somebody that hasn't. And I'm not saying that they should be barred from getting the case sealed, but maybe that would require either some letters of good character or some proof of rehabilitation, whether formal or informal, but some check on that, so that we can know that there were some eyes on that. I wonder about cases where there are victims, where there are really violent cases. What about domestic violence cases? I spent a long time in the Domestic Violence Bureau here, and I know that sometimes the conviction is just a glimpse of a larger problem or an ongoing problem. And when we have somebody that was convicted of a domestic violence offense, and we check back with the victim and find out that there's still an abusive relationship going on, still threats going on, whatever it is, I think that, and again, I'm not saying that these people should be definitely barred the way the statute is set up right now, but to have it happen automatically just seems to be, we have a responsibility to public safety that I think that we need to look into. The other piece is that, especially in today's climate, we are looking at incarceration as a last resort. And so oftentimes, we need a deterrent factor. And when somebody isn't serving a sentence that maybe going to jail certainly should act as a deterrent, but we want to have teeth in a felony conviction. And I'm not saying that this should ruin somebody's life forevermore, but there are certain circumstances where, you pled to a felony, and in, a matter of 3 years time, the effects of it just won't be there anymore. I think that doesn't necessarily provide the deterrent effect that I would like to see. And
Lisa,
then
let me stop you there,
Yeah.
because we're running a little bit on time, and I want to make sure that I get to other sections. And I think this is a great kind of transition point for Anna. And Anna, given some of what you've worked on and written about, I'm wondering if you can tell us a little bit more about kind of just what exactly a public record of conviction tells us. I mean, are there myths? Is there misstatements? We've heard about specific cases, but if we're looking broadly at the system, and how do those myths, misinformation, et cetera, how do those possibly fuel historical inequities when we're thinking about the system as a whole?
Happy to talk about all of that, and really happy to be here. So as you mentioned, I was a public defender. I was a public defender in Manhattan. And one of the hardest things about that work was discussing with my clients and thinking through with my clients some of the many things that deterred them from asking for a trial that they might otherwise have wanted to ask for. And so when I became a professor, that was a large part of what I wanted to study. And a lot of it is related to what we're talking about today. A lot of it is related to the impact of the criminal record on and on through the generations. So I'll give a couple of examples of what I'm talking about. One of them Avery has mentioned already, but the first one I want to talk about is that in almost every state in this nation, if you're facing a criminal trial and you have a conviction or more than one conviction, and you're thinking about possibly testifying, you have a pretty lousy set of options. One is to plead guilty. One is indeed to go to trial and to testify, but chances are you run the risk of your testimony being drowned out by the use of your prior conviction or convictions against you. Through questioning that will not just bring out that you have a conviction, but often what the name of the crime was, when it allegedly occurred, or when it's been found to have occurred, and oftentimes what the sentence was. And this covers not just felonies, but very often misdemeanor convictions too. Third option is you can go to trial, you can stay silent, but we're learning more and more from researchers how that, despite the constitutional protection against this happening, is oftentimes held against you by the jurors who want to hear both sides of the story, who are disturbed and who assume the worst when they hear nothing from you. And they also hear nothing from you that can express in a direct way your individuality, something that might help the jurors get out of their predetermined box of assumptions and group-based stereotypes. So researchers have looked into this issue and they've told us, for example, that folks who had stories of innocence to tell and who thought about telling them at trial were deterred from doing so by this fear more than any other, this fear of such an attack. They went to trial, they were convicted in the absence of any narrative from them. Down the road, they happened to be among the lucky few that were exonerated. But forget innocence, that's not necessarily my main focus. Whatever your connection to the alleged events, researchers tell us that this kind of evidence gets used improperly to condemn. So we have all this research, but despite the research, this practice continues daily in the courts of this state and other states. And I think it rests on, and I think it perpetuates a variety of assumptions that I see as flawed. I'll talk about those in just a second. The fundamental one, the one that folks don't necessarily like to talk about a great deal, is that this conviction can be taken to be a reliable indicator of crime commission. Having practiced in the system, having studied the system, I don't see that as a good assumption to make. Having seen, for example, the crushing pressure to plead guilty, having seen the shameful inequality of funding for the two sides, the shameful inequality and inadequacy of public defense resourcing, for example, and the lack of regulation, significant regulation of the plea bargaining process and of standards and resources for defense representation. Second assumption, even if we put all that to one side and say, I'm talking nonsense and let's assume a conviction represents crime commission, we also see happily and eagerly and openly voiced by legal decision makers assumptions about what a conviction means in terms of the character of the person involved. And I'm not going to relay the kinds of stereotypes you can imagine, but dive into the records of legal decision makers and you see what they think about what a conviction necessarily means, that it necessarily speaks to evil and morality and a desire to flout the laws of this nation, et cetera, defects in character, defects in background, on and on and on. So courts are worried that if you have someone get up on the stand and testify in their defense, that if juries don't hear this information, they're going to assume, in the words of one court, that this person is as trustworthy as a mother superior. That's one example. The second example Avery has already alluded to, and that's the fact that, again, in almost every state in this nation, if you have a criminal conviction, you are at risk of being automatically deemed disqualified for jury service. And even if you're not automatically disqualified, as you know, there's a whole range of stages of jury selection at which you're more vulnerable to be excluded. Maybe you never get the summons because you're not on the voting rolls. Maybe because of your conviction, you're deemed necessarily unable to be fair, or maybe you're tossed out with no reason given. Again, this is very common for folks with criminal records. So we end up with juries stripped of relevant experience. We end up with another factor that can deter folks even from going to trial. And we end up with a message that matters, a message sent both to those who are excluded and those who are not excluded, that there is this permanent civic unfitness, that there is this risk, that there necessarily is this danger. So that's the second example. This practice persists. 2, it again perpetuates those assumptions, A, of guilt, B, of what guilt is taken to mean. And again, you have the legal decision makers when they're justifying these exclusions openly and freely and without any supporting data saying a conviction means lack of trustworthiness, means lack of honesty, means lack of responsibility, means lack of fairness, lack of morality. So those are just 2 examples of what a conviction can do. I find these ones particularly fascinating because you can see how they fuel further convictions, whether they do that by making a guilty plea seem more desirable, not quite the right word, but more necessary, or whether they just make trial more of a doomed prospect. So the more we allow these practices, the more elusive freedom becomes, the more elusive full civic participation comes, the more we're reinforcing these notions of permanent unfitness, and the less the public has a chance to hear about, for example, law enforcement practices, to hear stories of that and how that affects individuals. And as Avery also said, and as is obvious, the racial and economic disparate impact in this area fuels those impacts in the rest of the system, given the way that convictions are unequally distributed.
Thank you. Valentina, we have a really good question from a Fordham University professor. I don't think we have anybody on the panel who believes that the Constitution should be interpreted according to the intent, the original intent of the Founding Fathers. The question is, can you address the original historic intent of these laws and policies post-incarceration? That's the question. If Michelle Alexander is correct that these collateral consequences are specifically designed to be the new Jim Crow, do you think advocacy work needs to address this elephant in the room, or do you just challenge the statutes and ignore their original intent? And Anna, Avery, Lisa, anyone want to tackle that?
Well, I can say just a word about that. The old civil death, which was the penalty for felony conviction, literally was sort of the prelude to real death. And you were wiped out as a legal entity, person, rather. There were a lot fewer things that constituted felony in those days, and felony was, I mean, it's pretty easy to get convicted of a felony these days. It was not so easy 200 years ago. So it was a much more serious sort of an enterprise back then. And the penalty was very, very drastic. Civil death. You no longer had any sort of presence in the legal system, and you could be discriminated against. And so it was worse back then. On the other hand, it was kind of harder to trigger all those consequences because the range of crimes that resulted in a felony was fairly restricted. So that's just a thought.
Thank you for the question. And thank you, Margaret, for your response. I could spend all day just talking about this. I mean, I find this question and this issue of factual guilt and the criminal conviction not necessarily conveying commission of a crime to be fascinating and very important to how we think about criminal convictions with respect to risk assessment and as Anna said, the lack of data, of research, of any information that underlies or would support this idea that someone with a criminal conviction actually poses a much higher risk to the workplace than someone without a conviction. And we don't have much time, and I do want to just get to our last questions, and this will be for Avery and Anna and Lisa and Margaret. But in terms of the first question, just in the era of mass incarceration, right? There's no denying that we are incarcerating people at a rate unforeseen and unprecedented, I guess I should say, and that there are more people living with criminal convictions outside of the prison and jail setting in the United States, many more, millions, in fact. But when we're thinking about accessible automatic expungement or some system of automatic expungement, and for the gains collectively, and both Anna and Avery touched on this, but for generations to come, when we think about generational wealth, and we think about generational wealth in the African American community, for example, in the United States, is being close to zero over the past 25 years. What would be the impact, do you all think, of accessible automatic expungement for future generations? And I would say for Lisa and anyone else, without automatic expungement, how do we fix the access issue, what Margaret was talking about, where you have a statute that is meant to cover and provide relief to many people, and a very, very small portion are actually able to access that relief, which has passed in the legislature and is part of the law. So maybe Avery and Anna, if we could just start with the first and some final words on kind of what accessible expungement would mean for larger communities and future generations.
I think there's huge gains if we have accessible automatic expungement inside of our community, right? Before I talked about that University of Michigan study, where folks are getting 22% higher wages. That's a big gain, right? I mean, we know that clean slate is a win-win for everyone if we were to pass like this legislation in New York, because we know that with 16059, most of those cases have happened in have gotten, accepted and moved in Nassau. And we heard that there was, people charging up to $10,000 to get that record, that record sealed. Like that's a wealth issue, right? Like Black and brown communities don't have that. But justice-involved people and their families will be able to earn a decent living, obtain stable housing, access to education and training they need to get ahead. The criminal justice system would not be burdened with the transactional cost of record clearing petitions, reducing a burdensome workload for the country's overtaxed courts. States will save taxpayer dollars as a result of reduced incarceration as the path of reentry is made smoother. The economy will benefit as qualified job seekers are able to reenter the labor force. Communities will be safer due to lower recidivism rates as more justice-involved people are able to move on with their lives and provide for their families. Our legislation has safeguards in place. As mentioned, conviction records are accessible at the sealing stage for professions where there is mandatory licensing, which includes many of the examples Lisa had gave, right? And this will not impact federal law and what applicants are required to disclose. So we have to say yes to all these things, all the harm that's happened that she named, right? And we're not suggesting that individuals not be accountable for their actions, but there has been accountability. And where is the restoration component? We see states like Massachusetts have some of these convictions, and there are, no major public safety concerns. It's a public safety issue if we don't allow people to move ahead. And we have to separate forgiveness from reentry when we're thinking about this as well. We're not discounting experience of people harmed, but it's a personal decision to forgive someone or not, and the court and the criminal legal system can't fill in that role. And we know that clean slate policies will help more justice-involved people get back to work, right? Benefiting the entire national economy. When you look on the CSI website, they often talk about the national economy loses as much as $87 billion in the GDP every year, simply by shutting workers with criminal records out of the labor market. So, those are some, that's some stats and some of the gains, right? If we're able to do accessible automatic expungement.
Thank
I
you
don't think
so
there's
much.
any question that automatic expungement is the goal, ultimately, at least for most convictions. But there are things that we can do in the interim. Let me just say that we're at CCRC, we're doing a study of access barriers. And the first state study went up on our website about 2 weeks ago for Illinois. And I can just tell you that New York has one of the narrowest eligibility criteria and has one of the stiffest procedures in the country. It's really interesting. If you look at the state by state information on the Restoration of Rights Project, you'll see that New York really is not the progressive jurisdiction that it sometimes likes to think of itself as being. And there are lots of ways, short of automatic, although I'm not saying that that's not where we ought to go, but there are lots of ways that we can improve accessibility. New Jersey, for example, has just instituted an e-filing system so that all of the requirements to serve agencies with multiple copies of certified documents, that's not going to be involved anymore. And so there are lots of little tinkering ways, whether it's resources, knowledge, whether it's eligibility criteria, whether it's intimidating procedures where you have to go back to court and go through a adversary hearing, or whether it's simply effectiveness. There are all these different ways that people are deterred. And I think that there are ways that you can improve those. And I really invite you to go and take a look at that Illinois study. It's very interesting. And we have a survey instrument that any jurisdiction can kind of test how their own system measures up. So, I mean, I think that there are lots of ways to improve. And certainly eligibility is a huge way in New York. You have one of the stingiest eligibility standards in the entire country. So, for what it's worth.
Margaret, a question.
Thank you so much.
What's happening on the federal level in terms of sealing and expungement?
Nothing, although we are hopeful that with the new administration, things will start to happen. I just want to say one small word for this poor beleaguered certificate, which actually has a pretty potent effect. I mean, it removes legal disqualifications. I've had a number of clients who, whether it's being a guardian for their elderly parent or getting a liquor license or even wanting to go hunting, it's been a really important relief mechanism. And it's also factored into the Human Rights Act. So it figures into a discrimination standard. So that shouldn't be, and we're trying to figure out, there's bipartisan support for a judicial certificate in the federal system. So we're working at it. We posted a reintegration agenda for the 117th Congress on the website. I invite you to go and take a look at it. There are a whole basket full of things that we'd like to ask Congress to do.
Thank you so much, Margaret. Anna, Lisa, any last word on this before we move to Q&A?
Can throw a couple of quick thoughts in. So how might moving toward expungement, automatic expungement, not just bring really important concrete benefits, but how might it shift the conversation in potentially really monumental ways? One, I think, stems from what I said about how much of my research indicates that legal decision makers here have enacted these policies justified by a sense of a conviction signifying permanent character defect of some sort. I'm sorry even to use this terminology. If you have an expungement in place, conversations can shift and a conviction can be seen for what it is at root, which is a governmental act, or certainly as something from which everyone can move on rather than this permanence. That could lead to a great many changes, including less of a reliance on a criminal system, because if we don't have this concept of criminality so ingrained, you no longer need the system or are thought to need the system. The other thing is, if this expungement is seen as a recognition of the hugely destructive effects of a conviction and how they are not justified by any purported benefits, if we apply that same analysis to other aspects of the criminal system, they may be found to need a change as well.
Thank you so much. And Lisa, I mean, I'm interested in terms of access, and do you think that there's an issue for fixing the access challenge if there is not expungement?
Well, actually, yes, I feel strongly about some points that have been raised. I mentioned earlier about getting the word out. I really do think that this should be coming from the state itself. There should be a huge push, just like buckle your seatbelt. get your conviction sealed. This exists. I absolutely think that it needs to be broadened. It is absolutely not capturing everybody, that should at least be able to have some, there should be discretion for many, many more people than the way it's currently drafted. Also, to Margaret's point, something that I'm constantly battling just on an administrative level, when I was a new assistant district attorney, one of the toughest things that I had to get my head around was how to serve and file a motion and what that meant. And young assistants who've been through law school and understand that parties need to be on notice. It's who goes where and who's on first and how many copies do I make and where do I bring it? And now maybe you live in Florida and you're trying to get something sealed in New York State. And maybe you're trying to do one conviction in Albany County and one conviction in Kings County. And it's really, really hard. And yes, it should either be online or at least just bring this to one place. And, certainly within Kings County, I'm fully capable of calling across the street and saying, hey, I got one, or vice versa. The other piece is it makes steam come out of my ears when I hear about these, cases where attorneys are charging exorbitant fees for something that really should be very simple. I've worked hard to try to make it more user-friendly so that people wouldn't be intimidated and feel the need for an attorney. Obviously, if we're opposing, which is a very small percentage of the motions that we see, if we're opposing, we say to the court, now this person needs to have counsel because there needs to be a hearing on this. But that's such a small percentage of the cases, and it really is outrageous. There should be some cap on what could be charged, or it should be strictly pro bono and farmed out to the numerous and zillion corporate attorneys that need to fill a pro bono requirement. Perhaps that's a solution, because this is really fill out an application, get some supporting documents, and get it in and get it on my desk or get it on the judge's desk. And we're seeing this process, when there's not a pandemic and we're digging out now from a backlog, it's like a 6 to 8 week process. I'm not sure. One of the panelists brought up that there was a 1.5-year process. I hope that wasn't in Kings County. I don't know why that happened, but some ideas.
Okay, thank you so much. So we have about 10 minutes left, and I will turn this over to Eric. I want to thank everyone, and I'll thank you again, but we'll hear from some questions that we had from people who are attending.
Thank you, Valentina. And I want to thank the panelists personally. There were a lot of questions. I think you answered some of them. I think the elephant is still in the room, but that's okay. The elephant's been in the room since 1776. Someone died in prison, and on the doc's website, it says discharged by death. It's 10 years later. That person who never made it out is deceased, and he still lives on the doc's website. We have been talking about perpetual punishment, and just one other example. Someone was engaged, his fiance knew about his criminal background, so they said, we're going to go up to Canada for a weekend. And because so much is accessible online, they went up there, they drove, they did whatever kind of check they did on him, and held him and really him, but his fiance had to wait for a couple of hours. So like the impact of this, where someone who just wants to go to Canada for a weekend to enjoy time with his fiance, because these criminal records live forever and they live everywhere, especially in this digital world. So anyway, someone had a question. Do you think being able to apply for expungement will be able to be done online? And is there a way to streamline the process? Because someone mentioned in the chat that people gave up on seeking certificates of rehabilitation because it just took too long. They were looking to get a job as a security guard, not the one where you can have a gun, of course, but the other lower level, and they just gave up. And it seems like society is sending a message to people with criminal records that we're not going to ever let you fully integrate into society. Do you think society is sending that message in some ways to people with criminal records? We're never going to let you fully integrate into society, that your punishment had a beginning, but it will never end?
Is that a question, Eric?
Yeah, that's a question.
Yes.
I know it
The
sounds
answer
like,
to the question
sounds
is
like I was on
yes.
soapbox.
Yes, that's
Yeah.
the answer.
Yeah, it's yes, I agree with Margaret, and it don't have to be that way. That's why
Right,
we're
right.
that's why we have these campaigns that are happening, because it shouldn't be that way. When somebody goes before the judge, they didn't sign up for a lifelong, conviction to follow them the rest of their lives. This perpetual punishment, this collateral consequences that we're talking about. That's not what they signed up for, right? So yeah, it's designed that way.
And someone wanted to know, how could formerly incarcerated people and their families, as well as family members of people currently incarcerated, get behind and support something like Clean Slate? What do they need to do? They need clear guidance on this.
If you want to support Clean Slate, go to our website, www.cleanslateny.org. We have a campaign, sign the petition, get involved in this campaign, talk to your local legislators and stuff like that as well. We have a bill introduced by Senator Myrie, going to be introduced by Assembly Member Catalina Cruz. It's movement time, so come and get involved and go to our website.
Thank you. There were a number of statements as opposed to questions in the chat, but someone wanted to know, I guess, this video will live on Wildcat's website, so you can go back and look at it and you can refer people to it for them to check out.
Yeah, I wanted to add one thing, because this is something that came up when Margaret was answering one of the questions and referring back to the old system of civil death. And I know that there's been this kind of new sense of the new civil death is, right? And this idea that it actually changes your legal status is changed, your legal personality is changed, that a state can implement a law that affects people with criminal convictions, and it can apply to you even though your criminal conviction was from 10 years ago. So there can be a new kind of complication or new restriction applied to you at any time because of the criminal conviction, which is, a different kind of legal status for people. And one, I think, even having done this work for a very long period of time, when you sit with that and think about how, how that impacts your perspective going forward, your access, and what we do as a society, this idea that folks are in this space where they are vulnerable to additional restrictions legally, meaning that the Supreme Court has said that that's all right at any point in time. And then also for defense attorneys, it's impossible for them to advise their clients on things that retroactively will impact them or on every single consequence. And they're also not required by law at this point to do that, with few exceptions, immigration being one of them, right? The impact of immigration. But that's just something that I wanted to pick up and kind of make clear in our conversation, because I know it was coming from different points during the course of what we've all been saying. And certainly is
Valentina, we have a question from one of our board members. Can we identify and outreach directly to the individuals who qualify for sealing with access to pro bono legal counsel to reach at least the 600,000 who qualify now? I think she's trying to give us some more work, but that's the question for you, Avery. How could we be involved and maybe help people secure pro bono legal counsel?
There's plenty of organizations, including CSS, the Legal Aid Society, Legal Action Center, and others that are helping folks get their records sealed, right? No charge and nothing like that. So folks can reach out to those organizations. And I mean, like, that's New York City. Also know, like, this is a statewide thing. But I'll also just name, like, even if we do the outreach, I think Margaret had put earlier, like, that study showed that less than 10% were like, with laws that have been in place for years, people have relieved themselves of that, right? Massachusetts has a very simple process, a simple application process, and is still being underutilized. So I think, like, that's why we talk about automation, because it's the way to go. Because when we're talking about giving folks access to generational wealth, all these different things that we talked about, I think it has to be an automatic process. We can do all these different things around 16059 in this application process, and it'll still be underutilized. So, we're doing work around the 600,000, and I think it's a long
Avery, you might look to see what they've done in New Jersey, pending development of their clean slate system. What they've now got is a clean slate. You have to ask for it. And now we have an e-filing, so you can sit at your desk and ask for it. And if you meet the eligibility standards, which are pretty objective, you get the relief. And so there, I mean, you never leave your desk. So that's kind of close to automatic. Yes, you have to ask, but there's no service to, it used to be you had to serve 9 different agencies in New Jersey with certified mail. Now you just have to do it e-filing. So, I mean, there are lots, and you don't go through a hearing. If you are eligible, you're done. And so I think that there are ways that we can sneak up on this.
Yeah, I think we can sneak up on it. I mean, Massachusetts is the same way. It's a mail thing. It's not online, but you download the form, you fill it out. It's granted if eligible. You don't go before the judge. It's still, like they're still having the underutilization issue too. So, I think it's a yes and.
All right. Well, we are at time, and I want to thank all of you so much for being here, for sharing your thoughts and your ideas, for talking this out with us. I'd like to thank everyone who attended. And as I said, we'll be sending some additional follow-up information so that you can learn more about Clean Slate, more about the individual agencies that these wonderful panelists are from and the work that they're doing. I hope you will join us again for our next Wildcat Community Think Shop discussion. We'll be sending out information on that soon. Thank you all very much. Welcome to our space, and thank you for being here with us.